Colleagues, friends, guests, thank you very much for coming this evening. You're giving us the most valuable thing you can, actually, which is your presence, your attention. So thank you very much indeed. And there's a lot of you giving us that. We've got over 500 registrations for people online and over 150 registrations for people who are coming to the room as they're coming in. And please just come through as you do come in. I'm Andrew Christie. I hold the Chair of Intellectual Property at Melbourne Law School, and I also have the privilege of being the academic host for the Francis Gurry Lecture Series, something that I've been privileged to do since 2009. Those of you in the room with me are on the lands of the Wurundjeri people of the Kulin Nations, unceded lands as we acknowledge in the law school, and let me on behalf of you all, if I may, pay our respects to their elders past and present. And those of you elsewhere watching this online, you're on lands of Indigenous peoples as well. And of course, to the Aboriginal and Torres Strait Islander people attending today, a very warm welcome. Those of you online will get the chance to pose questions to our guest speaker. Please do so in the way that I know you're now very familiar, using the Q&A function. And those of you in the room will also get that chance, and I think we all remember how to do that. We just pop our hand up and somebody will bring you a handheld microphone and you can ask away as well. And we will have very good time for questions. I know from looking at the registration list that many of you have been to a Francis Gurry lecture before, and it's delightful to see you again. I'll be brief for those who haven't. The history is that in 2009, the law school's distinguished alumnus consented to us establishing this public lecture series in his name. And as you all know, he is a very distinguished Australian, a former Director General of WIPO. The establishment of the lecture series was a joint initiative of the law school and the Institute of Patent and Trademark Attorneys of Australia, IPTA. And it's a delight that I have tonight representing IPTA, amongst other people representing IPTA, the President, Janelle Borum, who will assist me in the interrogation of our speaker later. The lecture series has from the very beginning had very great supporters, and it's a wonderful thing to know that there are people out there who will give you the resources you need to run an event like this. Let me name them, if I may, because it's so crucial that we have that support. And these have been with us basically from the beginning. AIPPI Australia, and it's a delight to have its president, Matt Swin, and its secretary, Tom Reed, with us tonight. IP Australia, and I'm very pleased that its Director General, Michael Schwager, is with us. IPSANZ, its Vice President, Ian Horrock, is with us, and LES ANZ, its Regional Chair, Jess Gords, is with us as well. So a very great thank you to our long time and much valued supporters and their representatives here this evening. Copyright, I think, without a doubt, is the most pervasive of the IP regimes. All of us, whether we want to be or not, are creators of copyright material, most of the time of no significant value, I agree, but we are creators. And all of us, a lot of the time, are consumers of copyright material. Not necessarily always of high value, but we do. And I'm sure it's the case that the US is the dominant producer of high value copyright material, and indeed the dominant consumer of it. So who better to have us talk about copyright than the lead US copyright policy person? In 2020, Shira Perlmutter was appointed as the Register of Copyrights and the Director of the US Copyright Office. Now that's not a presidential appointment. I mean, I know there's moves to make it so, but it hasn't yet occurred. And that tells us all, I know, that this is a meritorious appointment. Now, if there be any doubt that that be so, have a listen to this very brief but enormously impressive biography. After working in law firms and 5 years as a law professor and a period of time as a consultant to WIPO, Shira first joined the Copyright Office as an Associate Register for Policy and International Affairs. She then left for a period of time to work in the private sector, first as Vice President and Associate General Counsel for Time Warner Inc., and then subsequently as Executive Vice President, Global Legal Policy for the International Federation of Phonographic Industries, based in London. She then returned to the US to take up a government position in the USPTO. And she held that role as Chief Policy Officer and Director of International Affairs for IP. And that was all IP, not just copyright. Now, there's an interesting split, and we'll perhaps touch upon that this evening as to how domestic and international policy and copyright is dealt with. But note, the USPTO, the United States Patent and Trademark Office, and Shira was responsible for intellectual property matters there. And then finally, as I said, in 2020, the Librarian of Congress appointed her as the Register of Copyrights and the Director of the Copyright Office, with responsibility for domestic copyright policy and practice. So there is no one better placed, I'm sure you'll agree, to address us tonight on a couple of very important and challenging issues in copyright law. So please, in a minute, join with me in welcoming to the podium to deliver the 14th Francis Gurry Lecture on Intellectual Property, this one with the title of Art and Authorship from Warhol to the Creativity Machine, the 14th Register of Copyright and the Director of the US Copyright Office, Shira Perlmutter.
Well, thank you very much, Andrew, for that kind introduction. And I'm absolutely delighted to be here, first of all, to be visiting Melbourne for the first time. I've always wanted to come, and I'm very glad to be here. And I'm deeply honored to have been invited to give this lecture in honor of a longtime colleague and friend of mine, Francis Gurry. So I couldn't be happier to be here. So what I want to do is to talk about two high-profile copyright disputes in the United States involving works of art. And the first involves appropriation art, and that is, of course, the use of an existing work by another artist as material for a new work. The second is a case involving art created by artificial intelligence, and the questions that raises about the nature of authorship and the process of creation. Now, these issues are quite different, but both cases relate to how artists use tools to create, and the outcomes are likely to impact their ability to make a living from their art. So the first case is Andy Warhol Foundation for the Visual Arts versus Goldsmith, and it was argued before the US Supreme Court just last week, so this is very timely. And let me show you, this is the work at issue. It was a silkscreen created by Andy Warhol based on a pre-existing photograph of Prince. And just to give you background, there's an entire body of US case law that's been developed mostly since the 1990s that analyzes the application of our fair use doctrine to appropriation art. Now, the results have been inconsistent. Sometimes the courts have found fair use, and sometimes they have found there is not fair use. And the analyses, even sometimes in the same court and sometimes even involving the same artist, have differed significantly. Now, fair use always has a degree of unpredictability, but arguably you could say more so in these cases. And I'll just mention two cases involving Jeff Koons, very famous artist. One, Rogers versus Koons in 1992, the court found not fair use, and one, Blanche versus Koons in 2006, yes, fair use. Two cases also involving another Prince, not the musical artist Prince, but an artist named Richard Prince. One in 2013 finding fair use, Carew versus Prince, and one currently pending, Graham v. Prince, where the district court did not find fair use. Now, the results seem to depend primarily on whether the second artist is commenting in some way on the original, so there's arguably a need to use the original to make the point, or whether the elements that were taken by the second artist represent only small parts of a larger work. So the Second Circuit has talked about whether the second artist draws from numerous sources rather than simply altering or recasting a single work with a new aesthetic. But so a variety of results. Now, of course, in all these cases, the courts are applying the fair use doctrine, and the doctrine requires courts to consider 4 factors, at least, all the circumstances of the use, but including these 4 factors. Now, the first is the purpose and character of the use, including whether it's of a commercial nature or for nonprofit educational uses. The second factor is the nature of the copyrighted work. The third factor, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And the fourth factor is the effect on the potential market for or value of the work. Now, in 1990, Judge Pierre Laval, who was then on the District Court in New York and is now on the Second Circuit Court of Appeals, wrote an article in the Harvard Law Journal called Toward a Fair Use Standard. And this article became very influential. It introduced the idea of the concept of transformative use as part of the analysis of the first fair use factor, and that is the purpose and character of the use. And Judge Laval asked the question, does the defendant's work add something new with a further purpose or different character, altering the original with new expression, meaning, or message? And the Second Circuit took up that test in a case involving Two Live Crew and the song Pretty Woman, a parody case, which many of you will know, in 1994. And later courts were have adopted it, let's say, very enthusiastically. So this concept of transformative use has taken on such importance that in many cases it has tended to subsume the rest of the fair use analysis. I think some have said that over 90% of cases that find a use to be transformative then go on to find it to be fair use. So it's often given near conclusive weight. Now, against this backdrop, we have the Warhol versus Goldsmith case. Now, if you've read about this case or heard any of the press coverage, you would think it is another variant of the same issue, this transformative, this appropriation art issue. Could Andy Warhol legally use this photograph by Lynn Goldsmith without her authorization? But it's not that simple. This case raises some of the same issues, but the context is very different. And I think it's worth going into the facts to explain this. And of course, fair use is very fact and context intensive, and so it's important always to look at all the facts and circumstances. Now, the claim at issue here was not based on Andy Warhol's creation of the silkscreen, and in fact, that claim would have been barred by the statute of limitations. But it was a question of the subsequent use of these images. So let me go through the facts of the case. Lynn Goldsmith was a very and still is, a very successful and well-known photographer who specializes in photographs of musicians and particularly rock and roll musicians. And in 1981, she photographed Prince in a photo session at her studio. And Prince was then not yet famous. He was really an up-and-coming musician at the time. 3 years later, he had become famous, and Vanity Fair decided to run a story about him. So they went to Lynn Goldsmith and they licensed one of her photographs from that photo session. They paid $400, and the license was to allow the photo to be used as an artist's reference for an illustration. And this is apparently a standard type of license, that photographs are used for artist references. And the license had very specific terms. Vanity Fair could use the resulting artwork in one magazine issue and giving credit to Lynn Goldsmith. And Vanity Fair selected Andy Warhol to create the illustration. So he did, and he gave them this silkscreen purple Prince, the one in the middle. The one on the left, obviously, is the original Goldsmith photograph, black and white. He created the silkscreen, and purple Prince was given to Vanity Fair, and they published it with an article about Prince that was called Purple Fame in their November 1984 issue. Now, it turns out that Warhol, on his own, went ahead and created 15 other silkscreens and drawings from the Lynn Goldsmith photograph as well, and that became known as the Prince series. And the rights after Warhol died were owned by his foundation. Now, when Prince died in 2016, so this is all happening over a long period of time, Condé Nast, which was the parent company of Vanity Fair, decided to publish a commemorative issue. And they approached the foundation and learned that there were all these other works in the series, not just that original Purple Prince. So they decided to use the Orange Prince instead, and that's the one you see here on the right. And they paid $10,000 for it, and they put it on the cover of the magazine, both in print and online. So what happened, Lynn Goldsmith saw it at this point, and she contacted the foundation and said, look, this is based on my photograph, and I believe it's an infringement. So they actually went to court and sought a declaratory judgment that it was not infringing. So the trial court looked at this and said that this was a fair use. And again, not surprisingly, that decision was based largely on the fact that the court found it to be transformative. Now, why was it transformative? The court said, look, Goldsmith's photograph is a black and white photo that portrays Prince as a vulnerable human being. And the Warhol silkscreen is now portraying him as iconic and larger than life, and it's immediately recognizable as a Warhol. It went up to the Second Circuit Court of Appeals on appeal, and the court reversed. So it's a very good opinion, I recommend it. The court said, look, the determination of the trial court was based on a subjective evaluation of the underlying message of the works, rather than an objective assessment of their purpose and character. And that for a second work to be transformative, it has to represent more than just the imposition of another artist's style on the original. And here, the court said both works were intended to be portraits of the same person with the same purpose and function. And I found this interesting. The court talked about a concern that if this were considered transformative, that you might be creating a celebrity plagiarist privilege, where the idea is the more famous a second artist is, the more they could take a prior artist's work with impunity. The court also talked about the fact that the use affected the licensing market for Goldsmith for publishing her photographs, but also for creating new derivative works. And now, of course, the case is before the Supreme Court. So the government filed an amicus brief, and the Copyright Office worked on the brief with the Department of Justice. And our arguments were as followed. First of all, the purpose of the foundation's use here was the same as the purpose of Goldsmith's work, which was to depict Prince in a manner that could be licensed to accompany a magazine article about Prince. So this was not an article about Warhol or his art or his technique. It was not a museum exhibit of the silk screens, and both of those would be a very different analysis under both the first fair use factor, the purpose and character of the use, and the fourth factor, the effect on the potential market for value of the work. Second point that we made was really a doctrinal concern, but one with a lot of impact. If transformative use is interpreted too broadly, then it could end up undermining or even really eviscerating the derivative work right. Because the right to create a derivative work, which belongs to the original author, explicitly uses the term transform. So in US law, in the Copyright Act, derivative work is defined as a work based upon one or more pre-existing works, such as an art reproduction, and it lists a few other things, or any other form in which the work may be recast, transformed, or adapted. So you can see there's a certain tension there. If you talk about something being transformative, it has to mean transformative in a manner beyond what just transforming it into a derivative work would be. And of course, all derivative works, by their very nature, are introducing new expression, meaning, or message, to use Judge LaValle's language. So that can't be enough by itself to differentiate between a derivative work and a fair use of a derivative work, a fair use in a derivative work. For example, just think about a film from a novel. Of course, the film adds a lot of new meaning and message and transforms the novel, but that's a classic example of a derivative work that has to be licensed. So I thought it was worth telling you a little bit about the Supreme Court oral argument, which I attended last week. The Supreme Court just started hearing oral arguments in person since the pandemic about 2 weeks ago. And just to give you a little bit of color of what the court seemed interested in. First of all, as I was saying to someone earlier, the court seemed actually very excited to be, and very happy to be looking at a case involving art instead of some of the more hot-button political issues that they've been dealing with. But among other things, the court, the justices clearly were aware that there was a distinction between Warhol's original act of creation and the licensing context that the case presents. There were questions about the tension with the derivative work right and the definition of a derivative work versus the transformative use concept. And there was a lot of discussion of how transformative Warhol was as an artist and what he added. With one of the examples given of a Rothko painting, if it's a painting of just one color and then someone changes the color, how would you deal with that under fair use? There were questions about whether the test should be whether it was necessary to use the original to make the point. And then a fair amount of discussion about Warhol's paintings of Campbell soup cans and how that was different because that was a commentary on popular culture, consumer culture, and so the soup cans were part of making that point as opposed to another artist's creative expression. A lot of discussion about how do you determine the meaning and purpose of the second creator's works. Do you look at what was in the artist's mind, and how do you know that? Do you look at what critics see in the art, and if so, at what point in time? One of the justices raised the point that when Warhol started painting or creating, he wasn't yet known for being someone who was commenting on the commercialization, on mass commercialization of works of art. And then there were discussions about whether there should be an objective standard of how something can reasonably be perceived. Now, we'll have to wait a few months, probably until the spring, to find out what the Supreme Court decides. But this case is obviously important for artists. A narrow interpretation of what transformative use means could inhibit new creative works in the appropriation art genre in particular. But a broad interpretation could diminish existing and potential sources of income for artists like Lynn Goldsmith. So there are artists on both sides. And as the Second Circuit put it, the issue here doesn't pit novel forms of art against Philistine censorship, but involves a conflict between artists, each seeking to profit from his or her own creative efforts. So it's going to be very interesting to see what happens. But of course, what matters most is what the court says about the meaning and scope of transformative use, how it relates to the other fair use factors, and how it interacts with the derivative work right. And that will, of course, go well beyond the art world. And for that reason, there were multiple amicus briefs filed in the court by all the copyright industries, as well as a lot of groups that are involved in the use of copyrighted works. So let's move on to the second case, and this has to do with artificial intelligence. Now, we think of artificial intelligence as a modern phenomenon, but the copyright status of machine-generated works has been an issue since the late 19th century. So, very famous photograph of Oscar Wilde. In 1882, the Supreme Court in the United States had before it a case of whether this photograph could be protected by copyright. And the argument was made that it could not be because it was created mechanically by a camera just upon the click of the shutter. And the court concluded that the photo could be protected because the photographer's choices of the setting and the pose and the lighting and other creative elements involved demonstrated human authorship. Now, 8 decades later, the Copyright Office started looking at similar questions for works created using computers. And in the 1960s, the then Register said the crucial question appears to be whether the work is basically one of human authorship with the computer merely being an assisting instrument, or whether the traditional elements of authorship were actually conceived and executed not by man but by a machine. And in the 1970s, Congress created a National Commission on New Technological Uses of Copyrighted Works, known as CONTU. And the commission looked at the legal implications of works created by automatic systems of machine reproduction and concluded that copyright law excluded the protection of non-human creations. So this is not an entirely new issue. So the same report, the CONTU report, talked about the fact that computer science is constantly changing and these issues should be monitored going forward. And now, look where we are today. The issues are becoming more pressing now in the nearing the end of the first quarter of the 21st century with the development of AI systems that can produce very attractive and appealing music and artworks and poetry, often not distinguishable from human creations. So if you take a look at this slide, on the left you see a poem that was created by the GPT-3 language processor. And Professor Jonathan Zittrain at Harvard gave the GPT-3 processor, a prompt, which was, "My heart has mutinied," and asked it to create a poem. And now you see the outcome. So the poem, "My heart has mutinied. It has thrown my blood vessels into hopeless confusion. It has thrown down the gauntlet to my liver. It has taken charge of my tongue and of my brain and has collected the whole nervous system into a committee of ways and means." Now, you can see the artificial intelligence was able to capture the concept of poetry using figurative language, the idea that poetry often uses surprising and incongruous associations, like the association between the nervous system and a committee of ways and means. And whatever you think of this as poetry, if you were teaching a class and a student submitted this, I think you would give it at least a passing grade. On the right, you have an image that was created by the DALL-E text and image converter. And the prompt was "pop art kitten." And again, not bad. The artificial intelligence clearly understood the task and looks a little bit like an Andy Warhol silkscreen. So there are really two separate issues I want to talk about that are raised by artificial intelligence for copyright. And one is the authorship issue, and the other is the ingestion issue, and that is the input of copyrighted works as raw material for machine learning. And to start with the authorship question, take a look at this image. In 2018, Dr. Stephen Thaler filed an application with the Copyright Office to register a claim in a work called A Recent Entrance to Paradise. Now, as you can see, it's quite attractive. It looks quite creative. I've actually been thinking of putting a nice reproduction, framing it, and putting it in my office. But the author of the work in the application was identified as the creativity machine, and Thaler was listed as the copyright claimant by virtue of being the owner of the machine. So the examiner in our office declined to register the claim because of a lack of human authorship. And that denial was appealed to our review board. And on appeal to the review board, Thaler made three arguments. First, he argued that there wasn't binding authority prohibiting the registration of works produced by artificial intelligence. Second, he argued that the Copyright Office already registers works to non-human entities, in other words, corporations, under the Works for Hire doctrine. And third, he argued that it would be good policy to register these works. Now, the board upheld the denial. First, the basis was the text of the Copyright Act and how the courts have interpreted it. So the Copyright Act, of course, protects works of authorship. And in interpreting that, the term was left undefined by Congress, but courts have repeatedly said that it entails human authorship. And the review board cited in particular two cases, one involving the copyrightability of a photograph taken by a monkey, often known as the monkey selfie case, and second, a text that was purportedly written by divine spirits. Second, and I should say, the board also noted that the Patent and Trademark Office in the US had conducted a public inquiry into the IP issues raised by AI, and had found near consensus that such works cannot be protected by copyright because they weren't created by humans. As to Thaler's second argument, having to do with our registrations to corporations under the work-for-hire doctrine, the review board pointed out that under US law, work-for-hire status depends on a contract, either between an employer and employee or an independent contractor and the employee, the hiring party. For example, a newspaper article written by a journalist for the newspaper that employs him or her, the newspaper will generally own the copyright in the article. But of course, a computer can't enter into a binding contract and therefore can't produce a work for hire. And by the way, Thaler made a similar argument to the European Patent Office when he was trying to patent inventions purportedly devised by an artificial intelligence. And he claimed that the computer was his employee. And the Board of Appeals at the EPO also rejected the argument because a computer is not a person with legal capacity. So in any event, the works for hire doctrine can't really be used to get around the authorship requirement. It determines who owns the copyright, but if there's no human author, there's no copyrighted work to own. And then finally, the policy argument that Thaler raised was that if the office refused to register AI-generated works, that would invite applicants to lie to us, essentially, to falsely claim authorship of works that had in fact been created by AI. Now, the review board rejected this argument too, because fraudulent applications are not unique to the AI context, and our law has a number of penalties in it to deter fraud on the office. But in fact, I will note this scenario may have already arisen. There have been press reports about a successful registration of a work produced with the use of AI, where the application did not reveal that AI had been used. And if the office isn't aware of the facts, we don't investigate. We can't go beyond what's stated in the application. But we will not knowingly register a work that is produced without human authorship. So after the review board rejected his appeal, Thaler filed a lawsuit challenging the decision, and that case, which is called Thaler versus Perlmutter, is ongoing. Just as an aside, one of the dubious pleasures of being the head of this office is that you get named as a defendant in lawsuits. So it's the first time I've been a defendant in any federal lawsuit, in any lawsuit anywhere. But of course, the Thaler case only addresses the simplest AI authorship question. Thaler made very clear in the application that the work was autonomously created solely by a computer algorithm. And he's brought similar cases involving patents and inventorship to the US Patent and Trademark Office with the same result, a rejection of the application. Now, why does he do this? Because they're test cases. He's deliberately testing the boundaries of the law. But of course, there's many situations where humans will be more involved with works produced by AI. And at the other end of the spectrum from Thaler, you might find a human taking a photograph and then using AI in post-processing to clean up the image. And somewhere in the middle of the spectrum, you could imagine a collaboration where a human gives a simple text prompt, like Professor Zitrain did. The AI writes a poem, and then the human edits the poem. So the question is always, when does the human involvement cross the line, cross the threshold into authorship? And another question, what about co-authorship? So this is not purely theoretical. In March, the Canadian IP office registered a copyright in a painting called Surrealist, created at least in part by AI. And the application listed AI and a human being as co-authors. So here's what happened in this case. A human being selected 2 images as inputs for the algorithm. So there was a style image that would be used as a basis for a style filter, and a content image to which that filter would be applied. And the style image was Van Gogh's painting, The Starry Night, and the content image was this photograph of a sunset. The algorithm produced a version of the photograph in the style of The Starry Night, and that's what you have on the right. And the claim of joint authorship and the apparent level of human involvement distinguished the application from the recent entrance to paradise case. When the application was submitted to my office, the US Copyright Office, we rejected it because we couldn't identify the human contribution to the final work. The underlying photograph was by a human. The registration was sought for the derivative work created by the computer. So the question is, where's the human authorship in the derivative work, which is what the application was for? And I will note that the same work was sought to be registered with the Indian Copyright Office, which I understand at first registered it and then withdrew the registration. So countries around the world are facing the same questions. And even on the narrower question of whether a 100% AI-generated work can be copyrighted, there isn't unanimity. So notably, the UK will register AI-generated works under a special statute that predates the development of AI, which provides a 50-year term for computer-generated works. And they've recently reviewed that and have said they think these are early days, and until there's evidence that protection for AI-generated works is harmful, they're not planning to change the law. So we're going to see how national approaches develop and possibly diverge as we go further into this new world. One interesting question that was raised to me in a class recently is, what about national treatment? So if the UK decides to provide copyright protection to purely AI, well, as they do, but if they decide to provide it to a particular AI-generated work, and then the owner seeks to protect that in the United States, will we give it national treatment? And interesting question to think about. So let me turn to the second issue, the ingestion issue, which I think is arguably a more immediately important issue, the use of copyrighted works as training data for AI. Now, training AI requires supplying it with massive amounts of data, and that will often include material protected by copyright. Now, if you want an AI to distinguish a Rembrandt from a Renoir, or to produce paintings that look like a Rembrandt or a Renoir, you're going to have to show it a lot of their paintings. And here's an example. This image was the product of what's called the Next Rembrandt project. So it was produced by AI that was trained that way. Now, looking at this, would you be able to tell that it wasn't a genuine Rembrandt? Maybe, I'm sure that an expert art critic and historian could, but for the average viewer, perhaps not. And if you're working with more recent works, they're likely to be under copyright protection. And in fact, even if you're inputting mundane commercial texts, the odds are good that they contain some copyrighted material. And there have been different approaches to this issue so far in different regions. The EU Copyright Directive, the recent Digital Single Market Directive, introduced new exceptions for text and data mining, which do allow right holders to opt out with respect to commercial uses. This summer, the UK announced that it would expand its own text and data mining exception to cover any purpose at all without allowing right holders to opt out. Now, in the United States, AI researchers generally rely on the fair use doctrine, so they haven't sought new specific AI legislation from Congress. But because the fair use doctrine is so flexible, and because the application depends on the specific facts, there's a lot of uncertainty as to how and when it will apply to machine learning. And the leading US case on mass ingestion of copyrighted works is Authors Guild versus Google, where the scanning and copying of books into a searchable database was held to be fair use. The Court of Appeals found it significant that Google Books made it possible to text and data mine millions of books to discover the frequency of word and phrase usage over time, but it didn't allow users to see the full text. So that was the line that was drawn for a fair use analysis. And a year ago, the Copyright Office hosted an event on machine learning, and we heard from artists and scientists who've trained AI programs to create paintings and music. And one issue that was raised was whether courts would treat the ingestion of copyrighted works for expressive versus non-expressive purposes differently. Now, you can imagine feeding into the computer all the works of the Beatles in order for the AI to help identify trends in Western popular music from 1960 to the present. And if the output is a trend line or a table in a research paper, it seems quite transformative and unlikely to harm the original works in the marketplace. So a good fair use argument. On the other hand, you could feed into the computer all of the works of Taylor Swift, so it can learn to create music in the same style to compete in the marketplace with her music. Now, what if the AI's output is not substantially similar to any one of her songs, but nevertheless could potentially substitute for her songs in the marketplace? That would certainly be relevant to the fourth fair use factor, the impact of the use on the market for the work. So I imagine we're going to be seeing lawsuits in the near future that will test all of these scenarios. There are a lot of open questions, but the technology is evolving very fast. Week to week, we're seeing in the press new reports on what the technology can do. We've seen art created by AI winning awards now, so it's an extraordinary time. And of course, the technology isn't waiting for the law to catch up to it. So let me just close with a few policy issues that I think need to be resolved. Obviously, we're still looking at determining the application of existing national laws and the question of national treatment from an international perspective. But then the question is really, how should the law treat these situations? Do we want to change the law? Are intellectual property incentives necessary or desirable? Would providing intellectual property rights in the output of AI lead to more or better products or not? Is there sufficient incentive for people to write the programs and build the computers without also having protection for the output? Those are the questions we'll all be analyzing. And then what I think is very important to think about and worries me is what would be the effect on human creation and in human creators if we did protect the output. Would humans be rendered obsolete because the machines will create the next Beatles or Taylor Swift or whatever the type of work might be? Or are we going to, is it true that humans have an ability to be original and creative that computers will never have? They will continue to churn out things that are very similar to what's existed before, but they don't have that spark of creativity to move to something new and to the next level. That may be the case, but even if that's the case, if the computers are churning out huge volumes of works that are very similar to what people have found appealing before, will that diminish the markets for the truly creative human creations to the extent that humans will no longer be able to make a living from their creativity? And then last point, if fair use or other national exceptions do apply to the ingestion of the copyrighted works, should they? Even if the law would not prevent someone from being able to engage in those, in feeding the works into the computer, should there be some credit or some form of remuneration for Taylor Swift or for less famous and less successful creators because their creation has made possible this new work? So I leave you with those questions and happy to have further discussion.
Thank you. Take a seat. So we're open for questions. I've got my colleague Ben Hopper here monitoring questions online, and I'll check in a moment to see if there are any. And also I've got my own eyeballs here monitoring the room. If you're hidden by the podium, you'll have to be particularly hand-wavingly strong. So let me start. Ben, is there anything online that you would like to put to Shira?
Yeah, one question. Thank you, Andrew, that relates to a comment that Shira just made about remuneration for materials, artistic materials used to train AI, which is, could you comment on potential ways in which artists could actually be remunerated for the use of their works to train AI?
Yes. Certainly in the US system, it would require a change to the law. You would need to put in place some kind of remuneration right, and presumably, likely it would have to be administered by some sort of collecting society. And I think in most countries it would require a change in existing law.
Janelle?
Well, I'll ask a question. Well, Thaler has been active in Australia too, you'll be pleased to hear. So we've had decisions on patentability or ownership by virtue of inventorship by Davis. I'm just wondering if you were to look into the crystal ball into the future and if there is a change in ownership and authorship and like matters, what do you think will be one of the critical connectors between that authorship or inventorship and then who gets to own it? Do you think it's fair that it's the one who owns the machine that generates it, or could it be something else like programming or so forth?
Yeah, it could be programming. I mean, that's an interesting question. You would think, if you're thinking about it in the sense of traditional intellectual property, that the person who's responsible for the creation, which would tend to be the programmer, I assume these issues, either it will be the same party, the owner and the programmer, or these issues will probably be handled through contract.
Shira, I want to ask you to address one of those questions that you left with us. It's not fair to put them out there and not try and answer them. So let's go to one of those should ones, and that's really about, let me phrase it this way. A pure economist might well say to you, the purpose of copyright is to deal with the free writing problem, thereby which would lead to an underinvestment and undercreation of works if we couldn't prevent free writing, so we give time-limited exclusive rights through, amongst other things, copyright to creations. But that's predicated on the assumption that the humans know that there's a copyright law that gives them protection from free writing. So let me put it in its boldest form. How could it be that AI, whatever that means, and it's debatable what that means, know that there is a copyright law and therefore be incentivised to create? And if that's not possible, then what would be the justification at all for giving exclusive rights to AI-created works?
I think the justification, well, first of all, as you might have been able to tell from the way I presented this, I'm a bit skeptical that it does make any sense, and I think the existing state of the law in the US is a good one at this point in time, but I do realize that I don't know everything about this, and we are going to be, I'm sure, doing various studies and learning a lot more. I think the only justification would have to be that you're incentivizing the people who are programming the computer, who are doing the work that results in the computer creating. I did have someone ask a question in a class recently, why we should be discriminating against computers, and I thought, I'm not really sure how to answer that question, but so they seem to have a certain advocacy group out there.
Okay, thank you. In the room.
Hi there. Thank you for an excellent presentation covering a whole range of issues that are very live and active here in Australia right now as well. My question is about that possible divergence you mentioned across different nations about how this has been dealt with. I think we all like to have that consistent approach as much as possible so that investment and the economic rationale is as consistent as possible for different people in our society to do cross-border trade. So that's always interesting. How much divergence do you think is likely, and how long will that divergence be allowed to continue before there has to be some sense of international harmonisation that is led, presumably, from a multilateral forum?
Yeah, well, there are a lot of conversations going on led by WIPO. More and more these days, countries don't work in a vacuum. We all talk to each other as we are right now. So I'm hoping that there will be some consistency emerging. I mean, the fact I don't know exactly what led the Indian office to withdraw the copyright registration that they had issued, but it may be for some of the same reasons. So I'm hopeful that as we learn a bit more about what is going on beyond the initial test cases and we all talk to each other, there will be some convergence. And even the UK, which seems to be the most strongly on the other side of the issue, their conclusion in this recent report was a provisional one. They want to see if there's a problem. So I'm reasonably hopeful that we'll end up with some similarity in approaches.
Thank you. Ben, do you have anything you'd like to put from online?
I've got something interesting from the Australian Copyright Council, apparently, saying that they've remembered a TED talk in which a US lawyer and composer who was concerned about inadvertent copying of melodies. So he developed an AI to compose all possible melodies in the world in the hope of providing a free license to everyone. In such a case, there's no one that owns copyright in the AI's output. And I think the questioner would like you to comment on that. As in, is that a good thing or yes?
Well, I've seen reports of that. I would like to know more about it, honestly. So the idea is he is saying that he has produced every song that could ever possibly be written.
I think we assume that claim is right, and then consider what are the creativity incentive implications if that claim is right.
Yeah, I mean, it's interesting because, of course, there's been a lot written, including by courts, about how there's only so many combinations of notes that can be appealing to the ear in popular music. Like there's certain intervals that are hard to sing. You know, there's certain things that our ear just naturally likes. So to some extent, maybe every possible melody has already been created, but I suppose the way that it is sung, the way that it is combined with other elements may vary. So it's an interesting question. I'm not sure what the copyright implications are. I'm still thinking it through, but you know, the fact is still, if anyone else comes up with their own song that they didn't copy from his list of songs, they would certainly be entitled to a copyright and might, you know, another aspect of it is that's a little bit daunting, a database of every possible song ever written. So to what extent will that be useful to anyone? To what extent will it have any commercial success? Any song in that presumably billions and billions of songs in the database?
I've got a few questions in the room and then maybe back to Janelle. So whoever got their hand up first, you've got a microphone.
Hello, yeah. Hi, thank you so much for this brilliant talk. This particular case about Emil Kamandi, it's very interesting. A couple years ago, I published a paper in the Indian Journal of IP Law where I addressed a whole different question about the Emil Kamandi's, the art factories, modus operandi, which require temporary reproduction of existing art for the AI to sort of go through all of the existing art and then validate its own creation as art before it could be published and sort of like presented to its creator. And on the side of, while that raises primary questions about unauthorized temporary reproduction and whether or not this can be compared to the doctrine of inspiration, because if all humans are taught and we take inspiration from existing artwork, which is available for free in one form or another to us, then AI should be allowed an opportunity to also learn. And it sort of can be, there could be a separate exception carved under information analysis or data mining, which the Canadian office is sort of like looking into as well. But I'm sorry, but my question is more on the side of the authorship of this particular question as well. For instance, the next Rembrandt, and there's also an AI called Bob Dylan that can sort of like mimic and reproduce music of Bob Dylan as well. Unlike the situation that was presented by cases like Barrow Giles in the US or Naruto in the EU, where there was some sort of an effective causation or there was room to apply the but-for test, in such cases, the link between the author and the final art created by the AI is extremely tenuous. But which is why, then there are all these arguments about whether or not the justifications of copyright protection can be narrowed down to rewarding fruits of human creativity and labor or sort of to protect objects of commercial value. But what this exercise does is it does not look at the ultimate question of what the absence of protecting such works do. I mean, in one extreme, and the owner of the software can fraudulently appropriate the authorship title, and never present it to the world as creation of an AI and just their own creation.
So
Which is
maybe
why,
just if you could just focus to the question.
yeah, sorry.
Please.
The question is, which do you think we should sort of like move towards a sui generis regime instead of looking at protection of such works through copyright?
Possibly, but to me the issue is in general whether any form of intellectual property protection makes sense. And then there could be discussions about whether it's copyright or sui generis. It really would depend on exactly how you define and outline the scope of the protection. But I just will comment on one of your points also. I've thought a lot about this issue that human beings, a composer, will have listened to a huge number of songs during the course of his or her lifetime. And all of that goes into his or her thinking in composing the next song. And so how is that different from the computer having fed into it all of these songs and then drawing on those to create something new? And obviously, technically, the difference is that there's a reproduction made in the computer, which is not true for the human who just remembers and listens. But in terms of policy, I think all of that goes to the point under US law why it very well might be a fair use if it's only ingested for purposes of learning, but then that leads to that policy question of should there be anything done, even if you don't prevent the use in the computer, to respect and recognize the contributions made by all the people whose works were fed into it.
Can I just follow up on that sui generis point, if I may? Government in Australia just announced the other day that it's committed to introducing standalone legislation to protect and commercialise Indigenous knowledge. Now, that may be a particularly Australian issue here, but standalone suggests a sui generis system, i.e. not one fitted in or shoehorned into copyright patents, trademarks, designs. You seemed agnostic about whether sui generis or existing regimes are the preferred vehicle for extension of rights. But I'd like your comments, because you're so familiar with the international system. If it's shoehorned into an existing regime, we have a whole international infrastructure to deal with. We have treaties on copyright, patents, trademarks, designs, and all sorts of systems integrated. Are you truly as agnostic about sui generis protection versus existing regimes as you sounded?
In general, or
Yes,
with respect
just in
to
general.
AI?
Well, whether it's AI, Indigenous knowledge or anything, any sort of new right or extension of right, are you very open as to whether it be sui generis versus an existing regime?
No, not necessarily, but I just meant in the issue as to whether there should be rights in the output of AI. To me, the fundamental question is, should there be rights? And then the subsidiary question is, what should they be? But no, I agree with you that there's not, or I agree with the point I think you're making, which is that there's some issues, some areas where sui generis protection is more appropriate than traditional intellectual property.
Okay, thank you.
I was going to ask a similar question actually about your thoughts on having standalone forms of protection for such matters. Maybe it's a potential step into the future, but you've handled that one already, Andrew, so thank you for that.
Okay,
and I think
I can see that.
Thank you. Thanks, Janelle, for noticing me. Shira, over here in Australia with the patent office here anyway, our office seems to have, at least on the face of it, certain views on how the law should be and seem to want to influence the law as to how it should be. Does your office have a particular view as to AI ownership, whether it's copyright or patents? Do you try and influence the law, or do you just apply the law as it is and leave it up to the legislators and private sector to litigate it out and then deal with it as it comes?
Well, that's a good question. We do both. So on the one hand, in our role as registering copyrights, we have to make determinations about the law as it is and how it applies to the particular work before us. But we also do advise Congress and the courts and the executive branch on copyright policy. And sometimes we do that on our own. Often we do it in response to a request, especially Congress often asks us to do studies and make recommendations. We're about to start a study together with the Patent and Trademark Office of the intellectual property implications of NFTs, non-fungible tokens. And I wouldn't be surprised if a similar study on AI were far behind. So we do both. And then we also provide technical advice to Congress on just the drafting of legislation. And when I testify before Congress at hearings, I often get asked for my views on policy issues as well.
Ben, did you have a question online?
I have a question of my own, if that's okay, and I'll keep it as brief as possible. We live in an age of the making and production of works on an unprecedented scale, and this is intensified manyfold by the development of AI technology, which you've so nicely set out for us. Should we return to formalities? Should we return to a system of copyright registration, meaning that you only get copyright if you register it? And would that help to deal with something that Andrew mentioned in his opening remarks, which is that we are all infringing copyright many times, often innocently?
I don't think he said we were all infringing. I think he said we were all using.
Yeah, his comment, that may have been implicit but not expressed, yes.
I'm a firm believer that it is better to have a system without formalities for copyright. And I think there's been a long history of people losing rights and not being able to assert rights because of formalities that were imposed on them. I also think, this system is so deeply embedded now in the international framework from the Berne Convention onward that it would be very difficult to change it. But that doesn't mean that we shouldn't do whatever we can to make sure people understand what copyright is, that they know how to avoid infringement. I think there's a lot that can be done to improve the system. And one of our big focuses has been education and outreach and making sure people understand, especially in today's world where, as Andrew said, everyone is both a copyright owner and a copyright consumer, and we need to make sure that on both sides of the equation, or on all sides, because there's not necessarily just two extremes, that people understand the system and know what it means.
Thank you.
Thank you. And look, if time permitted, we would keep going and going, and it doesn't, because we have to respect the time frame we gave you, both online and in the room. So what I want to do is ask Matt Swin, the President of AIPPI Australia, to come forward and say a few words to bring our event this evening to a close.
Thanks very much, Andrew. One of the fascinating things about copyright law is how it does need to keep pace with the amazing advances in technology since it was first thought of around the printing press time, and to the creativity of artists in transforming and reinterpreting previous works. And it is clear from today's lecture that that remains very true today as the law seeks to grapple with the rise of the machines. It's my very great pleasure to offer a vote of thanks, first of all, to Melbourne Law School for hosting once again a very successful Francis Gurry Lecture, to Andrew and Janelle for their efforts at interrogation, and finally, of course, to Register Perlmutter for really a very fascinating lecture that was both informative in bringing us up to date on some of the hot button issues in US copyright law, troubling as an insight into the intricacies of US copyright litigation, and also thought-provoking about what may be ahead of us if we here in Australia also delve down the road of a fair use exemption. So on behalf of all of us here in the room and those who have joined us online, very many thanks, and I would invite everybody to show their thanks in the usual way.
Thank you.